Welcome and thank you for joining us. My name is Yoma Ojigoro, and today we will be discussing the Business Facilitation Act and its effect on the Trademarks Act. Now, on 14th February 2023, the Business Facilitation Act was passed into law with the objective of institutionalizing reforms in order to promote the ease of doing business in Nigeria. One of such reforms was the inclusion of services in the definition of goods and trademarks under the Trademarks Act. But the real question is, what does this mean? How would it look like for you and your business? And what effect would it have on the business space? To guide us in answering these questions, we have with us a seasoned intellectual property practitioner, a senior advocate of Nigeria, and a renowned author of one of the leading trademarks books in Nigeria, Mr. Mordi, SAN. So, sir, regarding the Business Facilitation Act, one of the major amendments we've seen is that they have now introduced the word services into the definition of goods. Now, there's been a lot of talk about how that will impact the registration of service marks. But the real question is, what are service marks?
Thanks. Service marks are names, logos, or brands that are applied to someone offering a service as opposed to a physical good. Okay. So a bank, for example, could choose to call a special service that it renders to the public with a specific name, and likewise a telecom company. So the service mark doesn't go on a physical product, but it's attached to the service that's being rendered. So that's what service marks do. So the whole idea about marks generally is to trigger in the mind of the population that product or that name goes back to a particular proprietor. So the same principle applies even to services. So when someone renders first-rate service and the business has a name, then when you mention the name, it engenders in the mind of the public, oh, it's that corporation that offers this wonderful service. So that's what service marks tend to do. So basically, it's applying the name to a service rather than a physical product. So, for example, another example I could use, Blue Band. Once you think of Blue Band, you think of margarine, and it's usually appended to a physical, top, which contains margarine or product, call it what you will. This is different because it's been applied to something that's intangible.
Okay, I think that's such a brilliant explanation because it just shows the distinction that you have when you have a product. You have more of like a trademark, and then when you have a service, you have a service mark. So the next question is, prior to the enactment of this act, the Business Facilitation Act, what was in play? How were service marks protected? Because now it seems like with the act, there's a lot of talk about the protection of service marks now, but what was happening in the past?
Well, pre-2007, if someone had a service mark that he wanted to protect, because the Trademarks Act 1965 didn't protect or does not define or does not even expressly create service marks. So it meant that, or the practice was that proprietors would register under Class 16. That's what they used to do. We used to cover paper or something like that. So that's what, proprietors used to do. But post-2007, there was a regulation made by the minister that seemed to, so what it did was that it changed the classifications and included in the Trademarks Act the NIS classification. Within the NIS classification of marks, you now had service marks. So that was the umbrella upon which or under which registrations of service marks from 2007, began to take place. So that was what was happening. So the real defect, maybe I should just point this out so that the history lesson is rounded out. The reality is that the Trademarks Act only defines trademarks to apply to goods which are physical, a physical product that you can see. But when it came to intangible services, that's what they call them, intangible services or intangible, goods, where someone is creating value that you can't readily see. But you experience in such instances. Those are called service marks. The Trademarks Act 1965 didn't have that definition. So that was why all of this became necessary, what I've tried to describe or flowing from your question.
Okay, so the creation of that class was done to mitigate the fact that it wasn't previously provided for. But it also begs the question, what happens to marks that were in existence prior to this Business Facilitation Act? So those service marks that were registered under that niche class, does this act in any way invalidate them?
Yeah, that's an interesting. In fact, it's the elephant in the room, if you ask me. Because the Trademarks Act 1965 didn't define or didn't provide for service marks, it meant that the validity of the 2007 regulation was always in question, because a regulation can only apply to existing legislation. It can't expand it. It would require an act of the National Assembly to create service marks. So that wasn't in fact the case. The regulator purported to, in my view, create a brand new class of trademarks by creating the possibility of registering service marks under the 2007 regulation. So what the BFA seems to have done is that it's now done, it's created by an act of National Assembly. It's amended the Trademarks Act 1965 and has created a specific genre of trademarks known as service marks. Now, the question is, what then happens to those that happened under the 2007 regulation? The question is, are they regular? Are they invalid? And if you want to deal with it in a very strict way, you would say it's invalid, because to the extent that the Minister of Trade in 2007 purported to increase the ambit of the Trademarks Act by regulation, it therefore follows that he didn't have the power to do it, because it required an act of the National Assembly. So it's possible. I mean, one very draconian view, one very strict view is that those marks are invalid. But I do think that the Trademark Registry, with its great powers, could look to do a clawback. That is to say, bring in those marks, or at the very worst, give them priority. In other words, they could simply make some fiat that would allow those trademarks, service marks registered since 2007 to become part of the trademark. In other words, as if they were created under the BFA of 2023. So that way they could save it. Ideally, what should have happened is that the BFA could have had some transitional provision that would have clawed back all those registrations that were done in 2007 up until 2022. But that didn't happen. So I think administratively the registry can do so, or find a way to do so, so that the proprietors do not lose the benefit of their marks, do not lose priority. So that's what I think could happen.
So I think basically what you said is the jury, or in this case, the registry, is still out on this one. And you'll have to watch and see how they interpret how they choose to recognize the previous service marks that were registered. But I'm sure they are...
I'm sorry, if I may jump in quickly. Provided the registry want to be innovative,
okay,
provided they want to be creative, provided at the back of their minds, they're saying, look, my priority is to protect owners or proprietors of trademarks who are trading, once that's the basis upon which they're trying to do what they will do, then I'm certain that the registrar has a kind of powers to save those registrations rather than have them dumped in the trash can.
I agree with your point, especially because the sole aim of the Business Facilitation Act is to promote ease of business in Nigeria. And so if you have proprietors who already have service marks that were registered, you are promoting ease of doing business by ensuring that they still retain the protection that they had previously. Which brings into my next question, because I'm sure there are proprietors, there are brands and businesses out there who may be panicking to say, okay, this act is out, but I registered my mark prior to this act. Do I need to re-register? Is it safer for me to re-register, or should I wait to see the determination or how things play out with this new act?
Good question. I think that I actually think it's better to be proactive and be on the front foot. So people who have those kinds of registrations, proprietors who have those kinds of registrations, should be quick to go to the registry and say, I need guidance. What should we do in this particular case? Will I get priority? Can you begin to give me priority now? Or will the registration that I do now be deemed to incorporate what I've been done in the past? And those kinds of questions. So once they put it on the front burner of the registry will be forced to come up with a solution. My thinking is that there should be some general fiat. That would be the easiest way to do it. Some general fiat that from the registry to claw back all those other, 2007 service marks. Yeah, that should do it, I think. But proprietors should be on the front foot. The registry won't do it for them if they don't come forward.
So basically, brands, proprietors, be very proactive with this new act, hinge on it, and try and see how you can continue to protect your business. So do you, in your honest opinion, do you think that this act conforms with international best practices or standards?
Yeah, I think it does. It now brings us in line with what's going on in the world, international best practices. I mean, the definition of Ghana's of trademarks in Ghana is extremely exhaustive. Likewise, in South Africa, I mean, it goes as far as not only covering service marks but designs. Yeah, so in some cases, a design may straddle the fence. That is, both be a trademark and a design. So in essence, that's how they do it. So our legislation was clearly archaic, and this has brought us into the 21st century.